Bismillahir Rahmanir Rahim. Assalamu alaikum, dear participants. Welcome to this third section of the Economic Sharia. We have discussed in the first two sessions the two statutes on which this Sharia is based. If you recall, we had shown that Ustaz Javed Ahmed Ghamidi in his book Meezan, also translated into English as Islam, a Comprehensive Introduction, has shown that the economic Sharia or the economic principles which we are discussing since the last two sessions are based on four statutes, and we have discussed two statutes already. The first of them was usurpation of wealth or devouring wealth through illegal means. The second was the national assets, which meant that things which are in public property must not be given in private property. Otherwise, wealth will start concentrating in the hands of few people. And three more, the third statute actually, and the fourth one we'll discuss today, and hopefully we'll finish off this topic as well in today's session. So the third one relates to evidence and documentation, and the fourth one to the distribution of inheritance. So we do have this important note to make, that as far as the system is concerned, which I have already talked about earlier, that there is no such system of economics which is found in the Quran, and it is a fruitless exercise to try to delve into the Quran to find an economic system or an Islamic economic system. What the Quran does tell us are certain principles or certain statutes, and we call these principles and statutes as the Sharia, as the economic Sharia, which means that these are the eternal guidelines which the Quran gives. As long as the system is concerned, it will be extracted and based on these principles, and this system will be different and could be different in different eras of time, and it could be even different in the same era in different societies, in different countries, depending upon the situation. So what is important is to note that as far as the Quran is concerned, it gives us guidelines or principles or statutes as far as this affair of economics is concerned. The system is left for human intellect to derive, and as I said, this is the work of people who understand these principles and are able to implement them. So we'll start off with this third statute, which relates to documentation and evidence. I already described this earlier on when we were introducing this whole topic, that an important area of Islamic Sharia is regarding economics is that all important transactions, which include loans, which include buying and selling, and especially things which are done or are struck, or the deals which are struck for particular specific periods of time, they must not be left to understanding, and they must not be just left to our vocal promises or vocal commitments that we make to one another, because they are bound to differ. People might understand differently, people might recall things differently, so it is essential that things should be written down, and not only should they be written down, but people who can be called upon as witnesses to this document are also needed, so that it's not just a statement of the deal that has been struck, but on top of it we also have individuals who testify and say that yes, we were a witness to this deal. So let's start off with the Quranic verses which actually deal with this documentation and evidence. These are two sets of verses, and the first set is the one that we're going to study first, and this is the set in which you will find that documentation on loan or documentation on people who have acquired loan is discussed. These are verses 282 and 283 of Surah Al-Baqarah, and then we will discuss another aspect of documentation and evidence when a person is not in his country and death might approach him, then what exactly he needs to do vis-a-vis writing down certain things about his life and his inheritance, and of course certain things which relate to his personal life. So let's start off with the Quranic verse. Because of the fact that it is quite a long verse, I am just going to read the translation of the verse before you, so that you can have an idea of what the Quran is telling us about this. So it says, "Believers, when you acquire a loan for a fixed period, record it in writing, and let a scribe write it down between you with fairness. And he who can write should not refuse to write. And just as Allah has taught him to write, he also should write for others. And the one who has acquired the loan should have the document written down, and fearing Allah his Lord, he should not make any reduction in it. So up till now, what the basic thing that has been delineated is that the person who acquires the loan, on him or on his shoulders lies the responsibility of documenting the loan. And of course, this is something which is very, very logical, that a person who is going to benefit from the loan, on his shoulders rests the responsibility of writing this document. And then the verse goes on to say, if he on whom rests the responsibility of writing is indiscreet or feeble or unable to have it written, then let his guardian do so with justice, and call in 2 male witnesses from among your men. But if 2 men cannot be found, then 1 man and 2 women from among your likable people, so that if one of them gets confused, the other reminds her. And witnesses must not refuse when they are summoned. And whether the loan is big or small, be not negligent in documenting the deal up to its period. This is more just in the sight of Allah. It ensures accuracy in testifying, and is the most appropriate way for you to safeguard against doubts. But if it be an everyday transaction, it does not matter if you do not write it down. So you see, the second part of this verse tells us that if a person who has taken the loan, he is not in a position to write it down, then he should actually call in some other person on his behalf who should do so. And then after that, once the deal has been written, once the loan document has been written down, then witnesses should be called in a prescribed manner. We'll discuss this in detail, the nature of these witnesses and the evidence. And also, it is said that if this is an everyday transaction, for example, if you're doing something day-to-day basis and you're just going to borrow something and return something the same day, and if you don't write it down, it doesn't matter, because day-to-day transactions, they have a very, very slim chance of getting into any dispute. But whenever you acquire a loan for a fixed period of time, then the directive is that it must be written down. So the verse goes on to say, and call in witnesses also if you sell or purchase anything. So another important thing is that just as witnesses have to be called in a loan document, in a very similar way, when you sell something or you buy something, again it should be written down, and the purchase must be not only recorded, but also it must be testified with the help of 2 witnesses. And then it says, and let no harm be done to the scribe or the witness. And if you do so, then this will be a transgression which will cling to you. So it's like an admonition being sounded to us that the witnesses in no way should be harmed, because this would be something against the statutes, against the whole deal and the spirit of the whole deal. And if you do so, this will be a transgression which will cling to you, and fear Allah and understand that Allah is teaching you, and He has knowledge of all things. And if you are on a journey and a scribe is not available, a loan can be taken by placing something in possession of the lender against the loan. Then when circumstances are such that people can trust one another, the lender should return the thing entrusted to him, and he should keep fearing Allah his Lord, and should call on people to bear evidence on this matter, and do not conceal evidence in whatever form it is. And remember that whoever conceals it, his heart will become sinful, and remember that God knows whatever you do. So at the end of this set of verses, it is said that if you are on a journey and a scribe is not available, then you can take something in return from the lender, of course, the person who is who's acquiring the loan, in return for that, so that you can have that safety that the loan would be returned and it shall not be tampered with in any way. But as soon as the scribe becomes available, it should be written down. So this is something which should only be done. This collateral should only be taken when there is no possibility of a scribe being present, and it is not possible to write it down. As soon as circumstances are such that scribes are available, obviously we also need to understand that this whole verse is placed in a particular background and culture of Arabs, in which, of course, scribes were never available when people were traveling by sea. And even on land, they were scarce, but of course, while on sea, this is not the case. But today, obviously, if such deals are struck, we do know that scribes can be made available while you are traveling, whether by sea or by plane. And even so, because of the fact that we very well know that this is something which will cause no harm. But what is forbidden is that if scribes are available, then this collateral should not be taken, then the security should not be taken. And the Almighty says that this is something that He is teaching us, and evidence, this is something on which witnesses should also be called upon, and they must bear witness to this deal that a person is not able to write it down, but he's taken security against the loan that he has given, and people are testifying to it. But as soon as circumstances are there for them to write it down, it should be written down, and in whatever form it is, it has to be understood that evidence must not be concealed. So this is the first set of verses, and you can see it's clearly a very, very important admonition, a very important guidance which is given to us. And there is this summary that we can draw from this whole set of verses. And Ustaz Amin Hassan Islahi has actually drawn up this summary. So I'm just going to quickly read through this summary, so that this longish verse, which encompasses many directives, some of which I've just referred to, are now brought before you in a sequential way, so that you can keep them in mind. So he says, I'm just going to read out from his book, Tadabbur Quran, a translation of Tadabbur Quran, where he has written regarding these verses. The first thing that he says is that whenever a loan is acquired for a certain period, the transaction should be written down in the form of a document. The second thing is, this document should be written down in a just manner by some scribe in the presence of both the parties. He should not be fraudulent in writing this down. The person who knows how to write should not refuse if he is called upon to do so. The skill of writing is a blessing of Allah, and in gratitude to this, a person should help others whenever the need arises. The need for this piece of advice arose because in those times very few people knew how to write. Formal and legal documentation and registration had not begun, and neither was its inception an easy affair. The third point in this regard is that the responsibility of writing down the document rests on the borrower, as we just pointed out. The document should state the name of the person from whom he has borrowed, and like the person who has been entrusted with the responsibility of writing down, he too should uphold the virtue of piety in this affair and in no way try to damage the parties involved. The fourth thing is that if the borrower is naive, is feeble, or is not in a position to write down the document, then his guardian or attorney should have it written down on his behalf with justice and fairness. The fifth point is that two male witnesses should testify over this document. The words used are min rijalikum, from among your men, which imply two things simultaneously. Firstly, the witnesses should be Muslims and known to the parties involved. The second thing which is specified in this regard is that witnesses should be honest and trustworthy and of sound character. I shall presently also explain more about this issue of witnesses, because on the basis of this verse, many of our authorities draw this conclusion that the witness of a woman is half that of a man, just as we have seen, as is stated allegedly in this word, or allegedly has been understood as well. The sixth point is that if two male witnesses having the said qualities are not available, then when one man and two women can be selected to fulfill the responsibility. The requirement for two women is because if one of them commits an error, the other may correct her. This is not because women are inferior, but because this responsibility is not very suited to their temperament and general sphere of interests and the environment they are used to. Consequently, the Shariah has given them some relief and sustenance in it. And Ustaz Ghamidi has written a short footnote on this, which says that this is a precautionary measure, and if it is not needed because of a change in circumstances undergone by women, following it also should not be essential. The seventh point is that people who have borne witness to a document should not desist from giving their testimony when they are called upon to do so, because bearing witness to a truth is a great social service, and as witnesses to the truth, it is a responsibility of the Ummah imposed on it by the Quran. The eighth point is, if the loan, whether it be small in amount or large, is acquired for a period and is not an everyday loan, one must not show aversion to writing it down. People who ignore this by considering it to be a burden sometimes get involved in severe disputes which produce far-reaching results merely because of this slackness. The ninth point that he has written is that all these directives are in accordance with justice, and they safeguard testimonies and protect people from doubts and disputes. So it is necessary to follow them for the general well-being of the society. The 10th point is that everyday loans and transactions are not required to be written down. So we just made this clear as well, that if these loans and transactions pertain to everyday dealings, then of course they don't need to be written down. It is only when they are done for a period of time do they need to be documented and also evidenced. The 11th point is that witnesses, however, should be called upon important deals and transactions to resolve any disputes that may arise. So even in that case, everyday transactions, it might be that you're not writing it down, but it should be that you call in witnesses so that any dispute can be avoided, particularly if the amount involved is substantial. The 12th point is that it is not proper for a party to harm the scribe or the witness if a dispute arises. Scribes and witnesses do a great social service, and if they are harmed, honest and cautious people will start avoiding these responsibilities, and except for professional witnesses, people will have difficulty in finding witnesses who are reliable. In present times, the reason honest and serious-minded people avoid these responsibilities is whenever some dispute arises in such an affair, the witnesses have to face a lot of trouble and discomfort. They become the targets of defamation, suffer monetary losses, and even get killed. The Quran has stopped people from such excesses and warned that this is not a small offense that may be forgiven. It is a transgression which will cling on to them, and they will not be able to save themselves from its evil consequences. So the important thing, which is again stated here, is that as far as these deals are concerned, one must remember that people must not show any slackness, not only in not writing them down or having them written in a very diligent way. They must also not harm the witnesses. They must not threaten these witnesses, because if they start doing so, then people who are responsible, who are honest, who are forthright, they will not come forward for this to fulfill this responsibility. As far as the issue of witnesses is concerned, because people derive this very important inference that a woman's witness is half that of a man, and they say so that not only in documentary evidence but also in circumstantial evidence, her witness is half that of a man, and this is the basis of their inference, this Quranic verse, which says that you can call in two male witnesses on this document of loan, and if two male witnesses cannot be found, then one male witness and the second male witness which is absent or cannot be found, and in his place two women can do the job. And as the Quran says, أَن تَضِلَّ إِحْدَاهُمَا الْأُخْرَى فَتُذَكِّرَ أَحْدَ. And if the first of them gets confused or forgets something, then the other one can remind her. So the important thing that we have to understand here is that this verse, first of all, is not referring to any particular form of evidence that is to be given in a court of law. So it's not a nisab, as we say in our technical terms, that it is describing. It's not addressing a court of law and telling the court of law or the judges present there that unless witnesses come to you in this proportion or in this ratio, then the whole case cannot be accepted or cannot be given a verdict upon. So basically this guidance is given to the society, to people, that if they are to write a document, then it is always good to have people who are more conversant, who are more comfortable with this job. And in those times, we find that women were not very accustomed to this issue of testifying, and they would get confused. And as Ustaz Ghamidi has also pointed out, that this was a precautionary measure in those times, because this was always a case that if one woman gets confused in her testification or testifying, then the other could have reminded her of this, whatever she forgot. So this is basically an advice which is given to the society, and this is not an advice which is given to the court of law. So the first important thing is that this does not constitute any specialized form of evidence which has to be admitted in a court of law. The second important thing here is that circumstantial evidence is being talked about. Is not being talked about. It's just the evidence which is documentary which is being talked about. The cardinal mistake which our jurists have made is that they have made this verse an analogy. They have drawn an analogy from this verse, and they say that just as two witnesses have to be appointed in the case of a documentary evidence, a very similar thing should work in case of circumstantial evidence. Now, this is a basic folly or a basic flaw in this analogy, and the reason for this flaw is that the two situations are entirely different from one another. In the case of a documentary evidence, it is upon us to choose who we would like to become a witness. We can choose men, we can choose women, we can choose a mixture of both. It's to us. I mean, we have the liberty because, of course, we can do so with freedom. But in the case of a circumstantial evidence, which of course relates to an instance of crime, for example, if a theft is being committed or someone is being raped, in that case, we are in no position to appoint witnesses. Whoever is there as a witness is a witness. So you see, there is this fundamental difference between the two situations, which makes an analogy absolutely baseless. You cannot regard the two things to be analogous, because in the first, you are in a position to appoint the witness. In the second, it's God's situation that has resulted in whoever is present there to be the witness. So therefore, as far as regarding circumstantial evidence equivalent to documentary evidence is concerned, it's something which just cannot be carried on. It's something which is absolutely baseless. So what needs to be understood is that as far as documentary evidence is concerned, this verse is only talking about that particular area, and that too in a manner that it is not addressing a court of law. It is addressing individuals for their own benefit, and of course relating to the circumstances of those times. If today, as we can see, circumstances have drastically changed, women can now go to courts to testify, so they don't need another woman alongside themselves for any help, then there is no such need that we can attach with this verse. So in short, what we can say is that this verse is just telling a Muslim society what to do whenever a loan transaction maybe or any sale or purchase is being made, and you would need to call witnesses over that. It's not drawing any form of principle regarding evidence and witness in the matter of criminal situations, such as I said, circumstantial evidence. It is just giving us an advice regarding documentary evidence, and that too in the background of a particular culture, of a particular society. If that has changed, of course, that precaution is no longer required as well. So the second important thing which the verse tells us is that if the scribe is not available and we are traveling, for example, so let me see that, let me just also read out what Ustaz Meezan Islahi has written in this regard, that when circumstances arise that people can start trusting one another and the lender does not have a valid reason to distrust the borrower, he should return the pledged item if he wants for his satisfaction. So in this regard, the borrower basically the borrower is given, he must return the pledged item. So the person who has borrowed, must return that pledged item and at all costs. He can adopt for the method on which he has been guided earlier in this verse. Examples of these circumstances are that this journey ends, scribes become available to document the transaction, and in the presence of people known to him, the loan becomes a verifiable transaction. Here the pledged items are called a trust, from which it is evident that these items lie with the lender as a trust, which he must safeguard. And it is prohibited to gain any benefit from them. As far as the details are concerned regarding the second instance of the set of verses in which the issue of documentation and evidence is concerned, I'm now going to read them out to you as well. These are verses 106 and 108 of the 5th surah, which is Surah Al-Ma'idah. Believers, when death approaches someone among you and he is making a bequest, the testimony will take place in a way that two just men from among you will act as witnesses. Or if you are traveling and the calamity of death overtakes you, then two just men from outside you should discharge this responsibility. Detain them, the two just Muslims, after the prayer. And if you have any doubts, they should swear by Allah, we will not accept any price for this testimony, even if some kinsman offers it. Neither will we hide the testimony of Allah. If we do this, then we would be among the sinners. And if it becomes known that they have proved dishonest, then let two others stand forth in their place from among the people who have been deprived of their right by these two witnesses, when they should swear, and then they should swear by Allah, saying, our testimony is surer than theirs, and we have not trespassed beyond the truth in our testimony. If we do this, then we indeed should be among the wrongdoers. In this way, it is more likely that they will bear true witness, or at least they will fear that their testimony may get refuted by that of the others. Do this and fear Allah, and listen and remember that Allah never guides the evildoers. Again, you can see that a short summary of the directive which have been given here can also be understood from these 6 statutes which are being summarized before you. The first of them is that if death stares a person in his face and he has to make a will regarding his will. So again, as I said, this basically, if you're to make a will, to bequeath something, to bequeath a legacy, and you are traveling and you are in a position that you are not at home, then what should be done is that you should call in two witnesses from among the Muslim brethren. The second point is that if death approaches him during a journey and two Muslim witnesses are not available there, then as a last resort, he can call in two non-Muslim witnesses. If there is a possibility that those selected from the Muslims as witnesses might show some bias to someone by altering their testimony, then as a precautionary measure, they can be held back after a congregational prayer in the mosque and be asked to swear by Allah that they will not alter the testimony for some worldly gain or in partiality of someone, even if he be their close relative. And if they do some alteration, then they will be sinners. The fourth point is the witnesses should know that this testimony is shahadatullah, which is the testimony of Allah. So even if they are dishonest in the slightest way, it would mean that they are dishonest not only to their brethren but also to the Almighty. The fifth point in this regard is that in spite of this, if it comes to surface that these two witnesses have shown bias to someone contrary to the will made by the deceased, then two people from among those who have become the victims of injustice should stand up and swear that they are truer than the previous witnesses, that they have not committed any excess in this regard, and that they will be wrongdoers before the eyes of God if they do so. And the sixth and the last point in this regard is that it is likely that after this further measure, the witnesses will not give a false testimony, for they will have the fear hovering above them that if they commit any wrong, others will negate their oaths, and in spite of being given preference, their oaths will be refused. So this is pretty much a very simple laid out procedure. If one is to make a bequest and he is on a journey, then how he could do so by calling in two male witnesses, and if there is something that he fears that might go wrong, then of course two other witnesses can also be called, and there is this whole procedure that has been laid out. Now, viewers, we come to the last point or the last statute of the economic Sharia, which is distribution of inheritance. And this calls for some detail. I will try to summarize this law in a brief way, and we will try to finish it off in this session as well. But one important thing is that this is one of the most outstanding pieces of research that has been done in recent times. And Ustaz Javed Ahmed Ghamidi, I have shown elsewhere in some of my other lectures in which a comparative study has been conducted between the view of in regarding Islamic laws of inheritance of traditional scholars with that of Ustaz Ghamidi's, that how the two differ gravely, and how if we follow the views of our contemporary scholars, then this inheritance cannot be distributed the way the Quran has said so, and you'll have to alter the shares in order to make them become distributed amongst the heirs, which of course is something very grave. And I'm not going to delve in that in more detail, because if you are interested to find out how our contemporary scholars understand these Islamic laws of inheritance, then I will refer you to my lectures on this topic, which you can see. And I think our admins here would also guide you towards those lectures. But today, in this session, I will just confine myself to how Ustaz Javed Ahmed Ghamidi has understood the law of inheritance as is enshrined in the verses that we are going to study today. All these verses are found in Surah Nisa, the 4th surah of the Quran. A bulk of them occur in one sequence in the initial part of the surah, and there is one particular verse which is found right at the end of the surah, which is like an appendix, a supplement to this law. So let us start off by studying this law of inheritance. And before we do so, one important thing that I'd like to point out here, which is that before the law of inheritance was actually revealed in Surah Nisa, a law was also given to Muslims that they should write a will in favor of these shares. So before actually adjudicating the shares, Muslims, just to make them accustomed to this distribution of money and legacy after them, they were given this order by the Quran, this command by the Quran, that whenever death approaches them and you are leaving behind some wealth, then you should write a will in favor of your relatives according to the conventions of the society. So it was left to the discretion of an individual. So the Almighty did not reveal these shares initially, and people were given their own choice to make anyone receive any amount that he would like him or her to receive after he passed away. And the only thing that the Quran said was that this should be done according to the custom, bil ma'ruf, of the society. Later on, this directive was revoked, it was abrogated, and the law of inheritance was revealed, so that once people came used to how this thing should be done, then the Almighty said, well, I will tell you how these shares would be distributed. Yes, now you have become accustomed to distributing your wealth, but since the basis of this distribution is something which might continue to elude you, so the Almighty said that I will come to your rescue and tell you how this distribution should be done. So the first verse which was revealed regarding this distribution is found in Surah Baqarah, as I said, and in this particular verse we don't have any directive vis-a-vis. We don't have any directive in distributing these shares in a certain amount as guided by the Almighty later on. It is left to a person's discretion, and the only thing that he is told is that he should do it according to the conventions of the society. So the verses read, these are verses 180 and 182 of the second surah, which is Surah Baqarah. It says, when death approaches any one of you and you are leaving behind some wealth, it is incumbent upon you to make a will in favor of your parents and relatives according to the conventions of society. This is an obligation imposed upon the God-fearing. Then if anyone changes the will after hearing it, then its sin shall rest on those who change it. Indeed, God hears and knows all things. But anyone who fears partiality or wrongdoing on the part of the person who has made the will, and he makes peace between them, then there is nothing sinful in this, for Allah is forgiving and ever merciful. So we can see from these verses that as far as writing down this will is concerned, the first thing that is evident is that it is mandatory. Kutiba alaykum iza hadara ahadakum al-maut, which means that it has been made mandatory upon every person to write a will, until of course the law was revealed later on. So he must write this will and distribute these shares, and if anyone changes the will after hearing it, then the sin will rest upon that person. But if anyone who fears partiality or wrongdoing then if he can make peace between the two parties, and he does do it by their understanding, then this is something which of course cannot be objected to. So this is the initial part of the directive or the guidance that was given regarding the distribution of wealth after a person passes away. Next we come to the actual law, which is based on a certain principle which we will discuss presently, but which is now laid out in detail in the Quran, in the verses of Surah Nisa that we are now just going to study. So this is based on a couple of sections, I would say. We have divided these verses in a few sections, 4 or 5 or 6 of them, and we shall discuss and debate on each of these sections so that you can slowly grasp how this inheritance can be gauged, the way the Almighty wants us to gauge it, and how we can distribute it. So it says, and what is left by your parents and those nearest related, there is a share for men, and from what is left by your parents and those nearest, there is a share for women, whether small or large, a fixed share. So the first thing that has become evident here and prominent here is that women cannot be deprived of inheritance, as was the case in pre-Islamic society of Arabia or the pre-Quranic society of Arabia. So the first important assertion which the Quran has made here is that just as men will receive and inherit from someone who is going to give them the money as being the legatees, in a very similar way, women shall also receive the money or the inheritance, and they too are the rightful and legitimate legatees. So this is a big headway, if you can call it, because in the times of the pre-Quranic society, this was something that was unheard of, and it's like the first step towards empowering women towards their rights as far as inheritance is concerned. The second point, which has some subtopics, we'll discuss them, is regarding the fact that we have to understand that basically inheritance belongs to the children. The basic recipients in the eyes of the Almighty are the next in kin, the children. Of course, the spouse, the parents, and the siblings, for example, they do figure, but then it is as if they are subservient to this main distribution. So once you dispense the shares from the parents, to the siblings, and to the spouses, whatever remains is for the children. And that is why these inheritance verses start off with this very important admonition and warning, I would say. It says that God enjoins you about your children that a boy's share is equal to that of 2 girls. And if there are only girls among the children, and they are more than 2, then they shall receive 2/3 of the inheritance. And if there is only 1 girl, then her share is half. We'll discuss why the Quran has said that a girl's share is half that of or a daughter's share, in fact, is half that of a son's share. This is an important area which again has raised a lot of questions regarding the law of Islamic law of inheritance, and we'll discuss it a little further down. But for the moment, all that we need to understand is that if a person has all sons in his children, then the wealth that he leaves behind for them shall be equally distributed among them. And if he has boys and girls, both genders are found, then the share of each boy or each son would be twice that of a daughter. And if there are only daughters, then the Quran says that if there is only 1 daughter, then it shall be half. And if there are 2 or more than 2 daughters, then their share would be 2/3. And that 2/3 would be equally divided between them. In both cases, you can see that 1/2 in the first case and 1/3 in the second case is a leftover inheritance. So this is something that a person can utilize by making a will, and we shall also discuss that as we go along understanding this law. So the first important thing that we have noted is that men and women equally inherit. It's not just that men inherit. The second thing is that basically this law of inheritance is for the next in kin, for the children. And for the children, the law is, if in the case of all the boys, the wealth shall be the wealth meant for the children shall be distributed equally between the boys. And if there are boys and girls, the share of each boy will be twice that of the girl, which is twice that of the son, of the daughter. And thirdly, if there are only daughters, then if there is 1 daughter, she'll have 1/2. Of course, the other half would remain. And if there are 2 or more than 2 daughters, then their share would be 2/3. Next, the Quran says, and if the deceased has children, then the parents shall inherit a sixth each. And if he has no children and only parents are his heirs, then his mother shall receive a third. And if he has brothers and sisters, then the mother's share is the same 1/6 after the execution of any law he may have, of any will that he may have bequeathed, and after discharging any debts he may have left behind. So next, we go to the share of the parents. So we just went through the share of the children. Next, we go to the share of the parents. And the Quran says, وَلِكُلِّ وَاحِدٍ مِّنْهُمُ السُّدُسُ, that if there are children, if a person has children, then the share of the mother and the father shall be equal, and that is 1/6. However, if he has no children, then the parents and the parents are the sole heirs, then his mother will receive 1/3 and the father will receive 2/3. So just make this a mental note and summarize this in your own mind, that we are now studying the shares of the parents. And the Quran says, and these shares, of course, as I said, will be given first. So the shares of the children shall be given at the end in the ratio that we have just discussed, and all the subsequent shares that we are now discussing shall be given first, because, as I said earlier on, according to this interpretation, it is basically the children who will be given this inheritance after, of course, the rest of the shares have been distributed. So the rest of the shares, of course, belong either to the spouses or to the parents or to the siblings. So the first of them are the parents. And the Quran says that if a person has children, then the mother and the father will receive equal 1/6 each. But if there are no children, if the person does not have any children, then in that case too, we have to understand that the mother's share will be 1/3 and the father will have 2/3. So in that particular case, the share will differ. With children, the share will be the same. And then there is another important thing, that if he has brothers and sisters, then the mother's share is the same 1/6 after execution of any will, which tells us actually that in the absence of children, the siblings they occupy their place. They are as substitutes. And if a person doesn't have children but he has siblings, then the share of the mother and the father will revert back to 1/6, which means that the father's share will be 1/6 and the mother's share will also be 1/6. And this is, it's very simple as we go along. So we've tried to simplify this law for you so that every person or any person who would like to distribute his inheritance or her inheritance, all that he or she needs to do is just go through this. And in the end, as we will summarize this law in the form of bullet points, you can just do this distribution yourself. The third important thing which these verses say is something that I'd like to elaborate before we go on, but let's first discuss the translation. It says, "You know not who among your children and parents are nearest to you in benefit. This is the law of God. Indeed, God is wise and all-knowing." So the important thing which we now understand for the law of inheritance, which is not mentioned in between, is that this whole law is based on the benefit which a deceased has for an heir. The more the benefit from an heir, the more his share would be. This is the most important statute of this law that has to be understood, that the law of inheritance, the Islamic law of inheritance, is based on the benefit or the potential benefit which a person or an heir has for the deceased. And the more the benefit which the heir has, the more will be his or her share for the deceased. And precisely for this reason, we can see that if the son's share has been twice that of the daughter, then it is because of the fact that the benefit that the son has for a potential parent, or the potential benefit that he has, is more than what a daughter has. This is because once a daughter gets married, then her benefit actually transfers to her husband. And she goes away, and in the Islamic law of society, in which, of course, the husband is the head of the family, now she goes away to another person and lives with her or with him, and he being the head of the family. So her benefit is transferred to her husband, and that is why her share is half. However, of course, there are instances in which women or girls or daughters, they don't go away and they do service to their parents, even more perhaps than their sons, then in that case we also need to understand from these precise verses that basically this law of inheritance relates to situations in which we have a familial relation. I mean, we are talking about the familial ties between parents and all those people who are concerned with them. As far as other bases of giving wealth is concerned, for example, doing some service for the parents or for the deceased, or for if the person or the heir, the potential heir is of any need, then of course a will can be made in that person's favor. And this would not be saying that you are making a will in favor of an heir, because making a will in the favor of an heir is of course not allowed, simply because in that case the Almighty already has stipulated how much you should give to your heir as far as the familiar ties are concerned. But if the case, as I said, is different, for example, because of any service done or any need, then some will can be made. And as I said, in this case, for example, if a daughter has not gotten married, or even if she has gotten married and she's still of more service than the son maybe, or equal service, then an extra amount can be given to the daughter by making a will in her favor, and this would not in any way infringe upon what she's already given as one half. This would be additional to that, and it could be much more, and this would be based on the fact that this will is being made on the basis of service or any need. And the need aspect, of course, is not to be ruled out as well, because there could be instances in which a daughter, maybe she's paralyzed, maybe she's not married, or maybe she doesn't have any chance to get married, and as such she needs more care. In that case too, a will can be made in her favor, and she can be given more than one half. And the reason that we can make this will is that this will is not being made on the basis of familial ties on which the law of inheritance is based. This will is based on a separate line of reasoning, and that is will which is made on service rendered, or will which is made on the basis of any need for the heir. So this should not be confused. But what needs to be understood here is that the difference in shares, according to the Quran, is because of the fact that the more potentially economically suitable or beneficial an heir is to the deceased, the more will be his share or her share. And if you just apply this law to all those distributions that we have just studied, you'll get a clear idea why the Quran has made this distinction. So therefore, for example, if a deceased person has heirs, then the father and the mother, they receive equal 1/6. This would mean that the benefit is equal for the father and the mother. But if the deceased does not have any children, then the Almighty says that the mother will receive 1/3 and the father will receive 2/3, because now the benefit, of course, of the father is more than that of the mother, because in that case, of course, he would be taking care of some other tasks and errands as well. So all that we need to do wherever there is a difference, and we need to understand this difference, is that we apply this particular Quranic verse, that it's the difference of benefit that a deceased that an heir has for the deceased, which governs this difference of distribution. The more the benefit, the more will be the share. And you can see that this is something which Ustaz Javed Ghamidi has also delineated in his Meezan. He has said that, for example, there could be instances in which, as the Quran has said, that Muslims cannot inherit from non-Muslims, or in fact the word here is kafir, and as far as the kafirs are concerned, they also cannot be inherit in this case. And the reason here is that once in the times of the Prophet, these people had become disbelievers by intentionally denying the truth, their benefit had ceased to exist for the believers, and therefore they could be deprived. So remember, this is a special law. It is not meant for all non-Muslims. It is just based, or this is meant for only those non-Muslims who had become disbelievers and by intentionally denying the truth. And therefore this particular hadith that you can see being displayed on your screens is related to the disbelievers of the times of Prophet Muhammad, because they were the ones who had intentionally denied, and hence had become they had lost that benefit that they could have for the believers. And this is something which is the Quran has said. And also based on this very principle, is another very important thing which has been drawn as an inference by Ustaz Javed Ahmed Ghamidi, and that is that wherever there is any inheritance which is being left over, then its decision shall be based on the benefit. Again, it's the same thing which is called nafr in Arabic and benefit in English. For the person who would a person get that share which is being left over. So the leftover share will go to the closest person, to the closest male relative, because in the times of the Prophet and even today, it is the closest male relative of a deceased who holds the most benefit for him. And if this changes, of course, then this law can also change. But the important thing is that leftover inheritance will also go to the nearest male relative, so long as that male relative holds the most benefit for the deceased. Now we come to the fourth part of this distribution, and that is that what exactly is the distribution vis-a-vis the spouses. And so this is now what we have regarding the Quranic guidance, and it is, and to you belong a half of what your wives leave, and if they die childless, and if they have children, a quarter of what they leave shall be yours after execution of any will they may have bequeathed, and after discharging any outstanding debts. And your wives shall inherit a quarter of what you leave if you die childless, and if you have children, then they shall inherit 1/8 after execution of any will you may have bequeathed, and after discharging any of your outstanding debts. So it's very simply explained in this verse, or this part of verse 12, and that is that if a husband if a wife dies, for example, and she has children, then the husband will inherit 1/4. And if she doesn't have, if the couple don't have children, then he will inherit 1/2. And on the other hand, if the husband dies and there are children, then the wife will inherit 1/8. And if there are no children, then she will inherit 1/4. Now, of course, you can again ask this question, that why is this disparity? Again, we'll refer to the same philosophy of inheritance which we have just alluded to, and that is the benefit which an heir has for the deceased. We just need to apply that. So whenever there is this situation of disparity, we can understand that this disparity is because of this fact. So for example, when a wife dies and she has children, then her husband will receive 1/4. But when she doesn't have children, the husband shall receive 1/2, which means that the benefit in that case would be much more when there are no children. So because now the benefit which was to be transferred to the children is no longer there because there are no children. So more wealth is being given to the husband. It is exactly the same in the case of the wife. The only thing is the proportion is different for understandable reasons. Now we come to an important area in which, if there is a leftover inheritance and you would like to make certain people to be inheritors or heirs in that leftover inheritance, and these heirs which are to be made, these people who are to be made heirs, in this case they are called kalala, which means that individuals which do not figure as children or as parents, all those individuals are called kalala, and the foremost kalala relatives are our siblings. They are the foremost, and other than that are aunts and uncles. Of course, they too are kalala relatives. So these are now directives that are being given regarding the kalala relatives. So kalala, what are kalala people? The kalala are those people, all those relatives which are neither your parents nor your children. So all relations except your parents and except your children, they are called kalala. And the most closest of these kalala relatives are your siblings, your brothers and sisters. So now the Quran says, and if a man or a woman is made an heir on account of his or her kalala relationship with the deceased, which of course is the same relationship in which you are neither the parent nor an offspring, and he or she has one brother or sister, then the brother or sister shall receive 1/6, and if they are more than this, then they shall be sharers in 1/3 after the execution of any will bequeathed and any outstanding debts, without harming anyone. This is a command from God, and God is gracious and all-knowing. And I think this is something very understandable. For example, if you are making someone your heir, and there is another person who also is of the same status in becoming an heir, then the Almighty wants us to not deprive that person of any wealth, and therefore in that case it says that if you are making someone an heir and he has one brother or one sister, then what actually should be done is that 4/5 should be given to the person who is to be made that heir, and 1/5 to his brother or sister, so that they also receive something. And if there are a number of brothers and sisters, then as the Quran says, then they shall be sharers in 1/3, on 1/3, and the 2/3 amount will be given to the person who's actually made an heir. So just to summarize it, when you're making someone an heir on the basis of your kalala relationship, and that person has one brother or one sister, then actually the heir that you are making will be just given 4/5, not 100%, just 4/5, and the remaining 1/5 shall go to the brother or sister, because the Quran does not want that deprivation to take place at that level. But if the brothers and sisters are more, then as the Quran says, hum shurakau fis sulus, then they'll be distributed 1/3 equally, and the 2/3 shall be given to the person who is being made that heir. This is as simple as possible, as you can see. Now there is this chance that if a person does not have any children, and he gives preference to someone else except his brothers and sisters, which are siblings, this could have happened. This could have arisen that you have kalala relatives in the form of your siblings, which are your foremost kalala relatives, but instead of your kalala relatives, you prefer some other uncle and aunt. So this could have happened, and this actually arose as a question in the minds of people, and they posed this question, and the Prophet said, and the Quran said in reply, that if this is the case, then if the person does not have any children, then his siblings will take the place of his siblings, and now you cannot prefer any kalala to those siblings, and that amount will be given equally. The way it has distributed to the sons and daughters it shall now be distributed among the brothers and sisters. So the important point here is that in the absence of children, the siblings will take their place. Otherwise, if this had not been given, this statute had not been given, people would have started to make other kalala relatives, which are other than your brothers and sisters, as their heirs, and this would seem very unfair, that you are giving preference to your aunts and uncles over your brothers and sisters. So this is posed in the form of a question in the last verse of Surah Nisa, and that is, people ask your pronouncement. Say, God enjoins you about your kalala heirs, that if a man dies childless and he has only a sister, then she shall inherit half of what he leaves, and if a sister dies childless, then her brother shall be her heir. And if there are two sisters, then they shall inherit 2/3 of what he or she leaves. If there are many brothers and sisters, then the share of each male shall be that of 2 females. God expounds unto you that you err not, and God has knowledge of all things. So you can see that how beautifully the Quran is balanced, and has said that if you don't have any children and you have a sister or a brother or more than one sisters and brothers, then the distribution will be exactly the same as is the case with children. So if there is one sister, she'll receive 1/2. If there are 2 or more than 2 sisters, they'll receive 2/3. And if there are brothers and sisters both present, then they will receive in the same ratio as with the brother getting twice that of the sister. And if they are just brothers, then the share will be distributed equally among the brothers. So you can see how beautifully the Quran has equated brothers and sisters with sons and daughters when the sons and daughters are not present. So in their absence, the same share, the son will be given, the share of the son will go to the brother, and the share of the sister, of the daughter shall go to the sister. So this is something which the Quran has pointed out. And this brings us to an end to this law of inheritance. And you can see, dear viewers, that if you have gone through this simple translation, how easy it is to distribute this inheritance. And not only is it is easy, it has been summarized by Ustaz Javed Ahmed Ghamidi at the end of this whole explanation that he has given. And if you follow this summary, by not even going into details, which I just went through for your own benefit, if you just follow this summary, it will give you a very nice way to distribute inheritance the way you would be tasked to do if there is any such situation arising in our families. So it's as simple as that. So let me finish off this session by reading out this summary and explaining it to you a little bit, and making you confident enough that the distribution of inheritance is something that can be carried out by any person. So the first thing is that if the deceased has outstanding debts to his name, then first of all, they should be paid off from the wealth he has left behind. After this, any will he may have bequeathed should be paid. The distribution of his inheritance should then follow. So this is the most important thing, that first of all, any will that the person has made, that shall be discharged. And I should also bring this to your notice that this will can be of any amount, as long as it is, of course, it is not unjust in any way, for which, of course, the Almighty will take that person to account. Any amount of will, the restriction which is generally imposed as 1/3 is also something which is gravely misunderstood. It was given as a suggestion of the Prophet to a particular companion, keeping in view his circumstances in which he had ended up thinking that, well, he'll give all his wealth for charity. And the Prophet said that, well, you have children, you should not do so. And that, in a particular background, was the suggestion that was given to that companion. It cannot be made a law as such. So the will can be of any amount. It could be given to anyone. Of course, it cannot be given to an heir, unless, of course, that heir is being given not because of being an heir, but because he has done any service, or she has done any service, or he or she has some particular need. Because now the will is not being made on the familial basis, which is the basis which the Quran has given the law of inheritance, but is being given on the basis of some need or some service rendered. No will can be made in favor of an heir ordained by the Almighty except if circumstances or the services rendered by him or his needs in certain situations call for it. Similarly, a person who has severed the foundations of kinship with a person through his words and deeds cannot be his heir. This is also an important thing to note, that you can deprive an heir of his inheritance or her inheritance when you can clearly see that the benefit he had or she had for yourself has totally vanished, is no longer there. For example, a person has ended up being extremely disobedient to the deceased in his life. He could be a person who has gone as far as to even kill the deceased, as is the case. So whenever this can be diagnosed that there is no benefit which an heir has for the deceased, or in all his life he had no such benefit, in fact he had inflicted grave harm, then in that case a person can deprive a person of his or her rightful heir. Because, as I said, this whole law is based on benefit. As long as this benefit is there, then the shares shall be distributed according to what the Quran has said. But then when this benefit is not there, then an heir can be totally deprived of his share as well. After giving the parents and the spouses their shares, now this is the important area, that you have to first give the spouses and the parents their shares, the way we have just described. The children are the heirs of the remaining inheritance. If the deceased does not have any male offspring and there are only 2 or more girls among the children, then they shall receive 2/3 of the inheritance left over. And if there is only 1 girl, then her share is 1/2. If the deceased has only male children, then all his wealth shall be distributed among them. If he leaves behind both boys and girls, then the share of each boy shall be equal to the share of 2 girls. And in this case also, all his wealth shall be distributed among them. We've already gone through this, so I'm not going to explain it. In the absence of children, the deceased brothers and sisters shall take their place. After giving the parents and spouses their shares, the brothers and sisters shall be the heirs. Again, we have discussed this. The proportion of their shares and the mode of distribution shall be same as that of the children. So again, we have discussed this, that in the absence of children, the brothers and sisters shall take their place in the same manner as the children were. So the son's share will be this, or the brother's share will be the same as the son's share, and the sister's share will be the same as the daughter's share, but provided that the sons and the daughters don't exist. Now, if the deceased has children, or if he dies, or if he does not have children and has brothers and sisters, then the parents shall receive 1/6 each. If he does not even have brothers and sisters and the parents are the sole heirs, then 1/3 of his wealth shall be given to the mother and 2/3 to his father. This is very simple. If the deceased is a man and he has children, then his wife shall receive 1/8 of what he leaves, and if he does not have any children, then his wife's share shall be 1/4. If, on the other hand, the deceased is a woman and does not have any children, then her husband shall receive 1/2 of what she leaves, and if she has children, then the husband's share is 1/4. we have discussed this as well. This change, again, as we said, is governed by aqrabu lakum naf'a, which means the person who is closest in benefit also has more proportion in the share. Now comes the area in which you can write a will in favor of the leftover inheritance to utilize it. So it says, in the absence of these heirs, the deceased can make someone an heir. If the person who is made an heir is a relative and has one brother or one sister, then they shall be given a sixth of his share, and he himself shall receive the 5/6. So let me make this small correction. Earlier on I said 4/5 and 1/5. It's not that. It's not 4/5 and 1/5. It's actually 5/6 and 1/6. So 5/6 shall be given to the person who is made an heir, and 1/6 to the remaining people. I mean, to the brother or the sister. It's not 4/5. Just let me correct myself. And if he has more than one brother and sister, then they shall be given a third of his share, and he himself shall receive the remaining 2/3. So in case there are a number of brothers and sisters, then, I mean, the person who is made an heir because of that kalala relationship, he shall be given 2/3. I mean, not the same. I mean, you not give 100% to that person, because we have other people of the same category existing. So the wisdom or the hikmah of this Quranic directive is that people who are of the same category, they must not be deprived completely. So if you are making someone an heir, for example, a brother or one brother or one sister, someone who has one brother and one sister, the Almighty does not want that one brother or sister to be deprived. So in that case, it says that 5/6 should be given to the actual person you're making an heir, and the remaining 1/6 should be given to those to that single brother or sister of that person. And if the brothers and sisters are of more than one, they are more than one, then the Quran says that 1/3 should be distributed amongst those brothers and sisters equally, and actually the 2/3 of that willed amount should be given to the person that you are making an heir. And this seems absolutely justified. So with this, my dear participants and viewers, we come to an end to the Islamic law of Sharia, or the Islamic Sharia of inheritance, as far as we have discussed this as concerned. And this also brings us to the end of the economic Sharia, which we have discussed in the last 2 sessions. This is the 3rd one. And for this, we conclude the economic Sharia as well. And just to give you this small recap, that this Sharia is based on 4 principles or 4 statutes. The first of them relates to devouring wealth through unjustifiable means. We discussed that. Then it relates to another area which we call the creation of a public sector or national assets, in which assets which belong to public property should not be given in private ownership. Otherwise, wealth will start to concentrate in the hands of a few rich people. The third related to documentation and evidence regarding deals, regarding loans, regarding various transactions that we do, which we studied today. And the fourth relates to this all-important area of the Islamic law of inheritance. And you can clearly see how simple this law is. All that you need is to follow it step by step, especially the last part, which is the summary. You can just go through it, the summary, and you can distribute any shares that might arise in case of death of a family member. And this also tells us that as far as this law is concerned, it is based on the closeness of benefit which a person has for the deceased. So this is the all-important thing that we have to understand. If there is any confusion, then this law of inheritance is based on this proximity of benefit. And secondly, the important thing is that this law is based on familial ties, on the ties of kinship. So this is basically how the Almighty has set it forth. But there are other bases of making a will, and that is, of course, we have referred to them earlier on, that if a person has rendered services, or if a person is in some need, in both these cases an extra amount can be willed, because now we are not making a will because of any familial ties. We are making a will on the basis of some other grounds, I would say. So thank you very much for bearing with this whole law of inheritance. Yes, it was slightly technical, but of course, now if you have any questions regarding this part that we studied today, or any other part of the Islamic law of Sharia that was discussed in the last 2 sessions as well, this is the time to raise those questions.
Thank you, Dr. Saleem, so much for such an in-depth and clear explanation. We have a question that asks, what is ma'ruf? Is it the norm of the society? if some unjust norm is set, then what will be the status of ma'ruf?
So you see, norms are always those which are called the good conventions of society. So the maruf can only be classified as something which relates to the good customs. Anything which is bad or something which is not good cannot become a maruf in a society. It can only be something which is being followed by a minority. And also, as I said, this is something of the past now, because giving someone on the basis of maruf was only the case when the law of inheritance had not been revealed. So it was something which was prior to the revelation of this law. People, in order to make them accustomed to the fact that they should give their wealth before they pass away, they were given this discretion that they could appoint an heir in accordance with the good conventions or the maruf of the society. But yes, as I said, this is something which has now been revoked, because once the law of inheritance has been revealed, now you don't need to go to the maruf. Now the maruf has been something which the Almighty Himself has delineated in the form of these exact shares that we have before us.
Thank you, Dr. Saleem. Ruhi Rasul, please go ahead. Ruhi?
Assalamu alaikum, sir.
Wa alaikum assalam.
Sir, if a person
Yes,
is
sir.
kalala
Yeah.
and after 10 years of their marriage, they still don't have a child, and now they have adopted two girls from government institution, Child Protection Bureau, and they want all their properties to be given to them. How they would be able to do that? I mean, he
So first of
has
all,
brothers and sisters as well, and parents as well.
So first of all, you have to understand that this is not the right meaning of kalala. This is something which we need to understand, that generally it is thought that people who die childless are called kalala. This is the conventional interpretation, and if you look at some of my lectures which have been given regarding the comparative understanding of the law of inheritance, then you will realize that basically there are two meanings of kalala which people have understood. One, that the person dies childless, which is the view of the majority or the conventional scholars, and I have shown in my lecture that how it is inappropriate to understand vis-a-vis these verses. These verses actually refer to those relationships which are neither the children nor the parents. So all relationships which are not your children or not your parents, they are called kalala. So first this correction needs to be made. But other than that, because this correction is something which actually does not have any bearing to the question that you have asked, except that you just need to correct this information. As far as the question itself is concerned, yes, the adopted sisters can be given any amount that the person wishes to give. And after about adopted daughters, so they can be given whatever amount the parents would like them to give. And once that has been given, the remaining will be distributed, the way the distribution has been just said. So this is a will that they'll have to make. They need to write down a will in favor of these daughters that such and such an amount should be given to them. Once this has been done, the remaining part is now termed as legacy, and this legacy will be distributed, of course, amongst the parents and the spouses and the sisters and brothers of the deceased.
Sir, suppose they want to give all of their property to their daughters, adopted daughters, as they are raising them just like their own kids. And of course,
So you see, in your own life, you do have this option to make a will and give it in your own life as a gift to your daughters. But this should only be done if you're not depriving those other rightful heirs of something that should go to them. For example, the parents, for example, the spouse, and of course the brothers and sisters. They could be in need, and only when you have an absolutely 100% surety that they don't need it, or maybe they forfeit their own share. Otherwise, there has to be some
they don't
justification.
need anything. They have their own sufficient shares.
Okay, so you have to be justified in your own conscience that you are not depriving anyone, you're not showing any injustice. If that is the case, then you can make a will in favor of both these adopted daughters.
Okay, sir. Thank you so much. Jazakallah.
Omar Farouk, you're up next. Please go ahead.
जी अस्सलाम वालेकुम
Walaikum assalam.
जी I have two questions. One is that sometimes we are distributing our hair in during life. What is the rules for that, or is it correct, or it is totally incorrect?
So when you would like to, let's do it one at a time. So when you are passing on your wealth or assets in your own lifetime to people, then this does not come under the Islamic law of inheritance. Islamic law of inheritance only applies on the wealth or assets that you leave after you pass away. But when you're living, you can give any amount to anyone that you wish, and this in classical terms is called heba. Heba means to give a gift. And as far as giving a gift is concerned, or making a heba is concerned, it has been left to your discretion. No rules have been made, no proportion or no percentages have been subscribed in any way or prescribed in any way. It's left to your own discretion. So you can give the property in your own lifetime to anyone that you wish. Of course, this underlying sense should be there that you are not doing this to unjustly deprive any other person of his share. But if you are totally convinced, then you can making a gift in your own lifetime is something that is your own prerogative. It's your own discretion. You can do that.
Jazakallah. My second question is that how can we prevent making unjust wills? I mean, like if any person is allowed to make a will as he wishes, I have seen many people that they make a will which is depriving many of their heirs, and they intentionally do that. So who will
So,
correct this?
in that case, the heirs can challenge this will in the court of law. And then a judge will take up the case and see that if this is done with a malified intention, with some ill intention, then of course it can be revoked as well. So whenever there is some injustice or some unfairness or foul play, then the people involved, they can challenge this in a court of law.
Thank you very much, Dr. Saleem. That was it for all of the questions today.